Good afternoon. My name is John Schmitz. I'm the Archivist and Historian for the Chautauqua Institution, and I wish to welcome you to this afternoon's Heritage Lecture. To come visit us at the Oliver Archives Center, which is just down here at the end of South Avenue, at South and Massey Avenues at the South Gate. We're open 10 to 3 Monday through Friday. And if you can't come in person, then please visit us online at archives.chq.org. Now I wish to ask Greg Peterson to come up to the mic to introduce today's program.
Thank you, John, and welcome. A couple of shout-outs before I get started, because John Schmitz mentioned the fact that all are welcome to come to the Oliver Archives. Go to the Oliver Archives because you'll see a collection like no other. And what it is a series of baseballs that I have donated to the Oliver Archives, autographed by people who have nothing to do with baseball. These are people who have come to Chautauqua, and it could be Peter, Paul, and Mary, it could be the Doobie Brothers, the Four Tops, Temptations, Mel Torme, even Marcel Marceau, who could write even though he couldn't talk. So all of those things, the Oliver Archives. Sorry, John, you're not making more of a big deal of that. I see Edith Everett over here, and I just want to shout out because they just had a wonderful community event honoring all of the activities of the Everett Jewish Life Center and everything that they've accomplished programmatically and as being a cultural part of this community. So thank you, Edith, for everything you guys have done. Also, as was mentioned, there will be a book signing over there, and the signing aspect is what's important because you'll get an opportunity for an autograph of the person who is the second most important judge who has roots in nearby Warren, Pennsylvania in its history. Second only to Justice Robert H. Jackson. And I don't have time to talk about Justice Jackson because I'm going to leave it to him, but I probably could. Geoffrey Sutton is a hotshot. He is a member of the United States Court of Appeals for the 6th Circuit, and he's been there since 2003. So think United States Supreme Court, think then right below it, Circuit Courts of Appeal, and he is on the 6th Circuit, which serves located in Columbus, Ohio. He's argued 12 cases in the United States Supreme Court, and numerous cases in the state Supreme Court and Federal Court of Appeals. He also was a law clerk for Justices Lewis F. Powell and Antonin Scalia. So maybe during the Q&A you might want to ask a question. Judge Sutton got his BA at Williams College and his JD from the Ohio State University College of Law. Since 1993, he has been an adjunct professor at the Ohio State University College of Law, and where he teaches seminars on state constitutional law, the United States Supreme Court, and appellate advocacy. He also teaches a class on state constitutional law at Harvard Law School. He's an author of numerous articles and a case book. And most importantly for our purposes, he's a 6th-generation Chautauquan. He's been here since age 4. Was that 10 years ago, something like that? And also what's really kind of interesting to a fellow lawyer like me is he is not only a well-respected, hugely respected jurist, but he's also a mentor, as his law clerks seemingly find a direct stream to being law clerks to the United States Supreme Court justices, and that's a tremendous compliment to Judge Sutton. So without any further ado, I'm thrilled to introduce His Honor Judge Geoffrey Sutton.
Thank you, Greg. I really appreciate that. Coming in second to Justice Jackson sounds pretty good. I think if you think a little more carefully about it, it's a little bit like the analogy of losing to FDR. It means you lost by a lot, number one, and number two, no one remembers who you are. So, but I'll take it. I have been coming to Chautauqua for a very long time. I've never spoken here, so this is a real honor. My parents met here, so for me and my kids, this This place has existential meaning, literally, to us. But the one thing I did think about before giving this first talk I've done at Chautauqua is I've come to a lot of talks at Chautauqua. I've listened to a lot of music at Chautauqua. And one of the great things about these open-air locations is there's an awful lot of things to do other than listen. So don't feel guilty if you daydream. I deserve it. I've daydreamed through quite a few symphonies and talks. But before you start daydreaming, I really have something that I at least care about deeply, and I think there's something useful here for me to say. So when nothing inspires confidence in a speaker quite like a stopwatch, and I'm going to start mine and go no more than 25, 30 minutes and leave plenty of time for questions, so I hope I provoke a few. So I was coming out of my Presbyterian church a few weeks ago, and a doctor friend of mine came up to me and said, "Oh, Jeff, I hear you've written a book. That's so exciting. Is it an autobiography?" And I said, "Oh, not exactly." "Is it a mystery?" And I said, "No, not exactly." "Well, Jeff, what is it about?" And I said, "Oh, state constitutions." Dr. Briggs paused for a second and said, "You sure it's not a mystery?" So the truth of it is there actually is a little autobiography and there is a little mystery, and I hope I'm going to find a way to make this interesting to you one way or another. So there's a why to why I did this, which is quite autobiographical. So when you read books about constitutional law, and many of us know many constitutional law stories, including Burnett, Brown versus Board of Education, they're dominated by conversations about the U.S. Supreme Court and the U.S. Constitution. They neglect the state courts, and they neglect the state constitution. So that's one common theme of really all books about constitutional law. There's another common denominator among all of these books, in that it's not hard to figure out the narrative. The narrative is usually states as villains, U.S. Supreme Court as heroes. Now, I didn't set out in this book to contradict that story because, sadly, there's quite a bit of evidence to support it. But I did think it might be useful to supplement that story with some examples in which states actually rose to the occasion, and a couple cases where the GOAT, in truth, was the U.S. Supreme Court. There's another kind of autobiographical component to this, and that's that I, like all law students when I went to law school, never studied state constitutions. They don't talk about it. They want to talk about the U.S. Supreme Court and the U.S. Constitution. That's not just a problem in law school, that's a problem in civics education in general. There was a poll not too long ago which asked people if they knew their state had a constitution. And fewer than 50% of the people taking the poll knew that their state had a constitution. So we're really dealing with an uphill problem. The last reason I was interested in this is autobiographical as well. And that's that for the last 15 years I've been a federal judge. And you might think that's odd. Why would a federal judge care about state constitutions? I've actually had only one case about state constitutions in 15 years. So that seemed quite odd, a little bit jarring. Well, the explanation is something I've witnessed since my first day of law school in 1987. And that's a pattern that seems to continue to grow every few years, of the U.S. Supreme Court seeming to have a bigger role in our lives, for better or worse. For better when we like what they do, for worse when we're not happy with what they do. And what I've noticed during that time, particularly the last 15 years, is the American people have come to care deeply about what the U.S. Supreme Court is doing and who is on the U.S. Supreme Court. Because if you have 5 justices that share your views, that can be very consequential for getting a winner-take-all ruling at the court. Well, the American people aren't fools. They've watched this happening for several decades, and of course, they have become very invested as to who's on this U.S. Supreme Court. Indeed, you could almost say, I mean, there's some evidence for this, that our last presidential election was arguably a presidential election using the president as a proxy to fill one open seat in the U.S. Supreme Court. That's odd. That's not what we, I think, created this country for, and there's something amiss when we're so focused on what they're doing and we care so deeply about it. To many people, June is the cruelest month for some. That's when they announce their most significant decisions, and the happiest month for others. They really are exercising a lot of control. So I see 2 paths forward with this continuing role of the U.S. Supreme Court in making central decisions about the way this country works and about significant policy issues and social issues in this country. Path A is very much the path we are on, and that's that one political party does the best it can to win control, get judges on the lower federal courts that share their views, or on the U.S. Supreme Court best of all, and then they do their best, they get their rights, we'll call them liberal rights to generalize. The conservatives aren't fools, they try to do the same thing and they get their conservative rights, and it's just up, 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 up. More rights recognition, and more rights recognition means more control by the U.S. Supreme Court. That path, I think, is going to be very hard to get off, but I don't think it's going to end well. In fact, I think it will end in tears, because I think we're going to have a difficult time filling those seats if these people on the court, just 5 of them, are exercising so much power. Well, I'm a Chautauquan, which means I'm a dreamer, and it means perhaps there's a path B, which is better than that approach. And the path B for me is a detente, where the U.S. Supreme Court is a little more hesitant before it recognizes these new rights, is a little more patient. That's a very hard path to get on, because we Americans love our constitutional liberties. It's something, it's very much a story of who we are. The Brown versus Board of Education illustrates it perfectly. So does the Barnett story, that the court looks after the little guy. And the real problem in America today is, who exactly is that little guy? Who exactly is the minority? Where so many people are contending for that and trying to get these winner-take-all victories at the U.S. Supreme Court. Well, if we care for judicially enforceable rights so much, how do we get the U.S. Supreme Court off that path? The only way that makes any sense to me is to give the state courts a greater role than they have had over the last 50 to 60 years in enforcing rights, which allows 2 possibilities. It allows for the possibility that state courts can customize rights to suit the region in which that court appears and pay attention to the history, traditions that particular area has. That can be useful by itself. The other thing that goes on when you rely on the state courts a little more than we have so far is it allows the U.S. Supreme Court to be a little more patient before it nationalizes a right. If the U.S. Supreme Court nationalizes a right that 45 states already recognize, that's not an earth-shattering development. It's a big development in those 5 states, but it's not a national development. It's not the kind of development that is going to flip a presidential election, which it seems to me is really potentially happened in the past and might well happen again in the future. So how do we get the state courts? So that's the why. Now the what is, what do we do to get the state courts taking more seriously their role in construing their own constitutions? Well, oddly enough, this should be very easy. Every single constitutional liberty that we care deeply about, liberty rights, property rights, rights to privacy, I don't care what the right is, every single one of them originated in the state constitutions. So the path I'm trying to get us back on is the path where we started. From 1776 to before the summer of 1787, the framers of the original state constitutions authored all of these Bill of Rights type provisions. In the summer of 1787, I mean, it doesn't make for a great musical, but it could well have been called plagiarism. Everything they adopted in the summer of 1787 that's an individual right and that we prize so much came out of those state constitutions. So that it shouldn't be a hard thing to do to take seriously guarantees that started in the state constitutions and were initially enforced in the state courts. That shouldn't be that hard a path to return to. The next point, and this is where my friend Dr. Briggs was right. This is the mystery part of this. Forgive me, but it's so important and I care so much about I have to say it. When the framers started this experiment with the U.S. Constitution, they thought that they would have exclusive, separate spheres of lawmaking authority. With federalism, they split the atom of sovereignty, and as you probably realize, splitting atoms can be a dangerous thing, and it also just doesn't really make much sense. You really can't split sovereignty. So the half-baked, practical political solution of the federal framers was to say the federal government could do some things, initially fairly limited things, and the states would do the rest. Now, I pointed out the state constitutions had these liberty guarantees, and the way it worked was we had separate spheres of power and separate spheres of limits on that power. The state courts and state constitutions would limit the lawmaking power of the states. The federal Constitution's Bill of Rights would limit the powers of the federal government. Well, that was 1789, and that is not the Constitution we have today. We have the 14th Amendment in 1868, and we have the U.S. Supreme Court decisions in the 1930s. The upshot is twofold. We now have two sets of governments with overlapping powers. We live in a world in which the federal government can regulate most everything, and the states can regulate most everything. What has come with that? A world in which the federal Constitution now applies to the states, and of course the state constitutions still apply to the states. So that mystery can be resolved by a very simple analogy to American basketball. If you don't like a state or local law anywhere in this country, you have two shots, not one, to invalidate that law. You can use the state constitution, because remember, every guarantee we care about came from the state constitutions. Free speech, free exercise, equal protection, due process. Just read the New York Constitution. It'll take a while, but just read it. They're there. And then, of course, we have the Bill of Rights and the 14th Amendment as well. So it's very strange that we Americans are not used to taking two shots when we have that opportunity. But we live in a world where we are so focused on the U.S. Supreme Court and the U.S. Constitution that for reasons of our own, we focus just on the U.S. Constitution when it comes to protecting our rights. Now, I get it. If I'm an interest group or I'm an individual, I would much prefer to see my right nationalized. I prefer to see everybody recognize it. I prefer uniform treatment. But the reality is you can't win them all, and sometimes it's appropriate to respect the regional differences we have, at a minimum to slow down the nationalization of the rights, and every now and then to leave these regional differences where they are. So why might a state court chart a different path, a more aggressive rights protective path than the U.S. Supreme Court in construing its state constitution? Well, sometimes it's just a function of the language of the state guarantee and the history of that state. It turns out that while all of our federal guarantees originated in state constitutions, the language of the state guarantees often differs. Differences in language lead to differences in meaning. Sometimes, however, the best explanation is an historical one, and I can illustrate it by just thinking of three states. Think of Maryland, Rhode Island, and Utah. Those are three states founded by religious dissenters. It should surprise no one that the state Supreme Courts in those states would more aggressively, more carefully, more muscularly construe the free exercise guarantees. They lived the problem of being a religious dissenter, and you'd think they'd be very respectful of that particular problem, even in America circa 2018. So differences in text and history can lead to a difference in meaning. So also can sheer disagreement. One illustration of the fact that we Americans are now obsessed with the U.S. Supreme Court is what I'm about to say. I can now speak to a general, albeit highly educated audience, and say there is a difference between originalists, living constitutionalists, and pragmatists at the courts, and you'll know what I'm talking about. Shame on you, that's embarrassing. You have better things to do with your time. But the reason you know the differences, and the reason you know they matter, is because you've been reading a lot of stories about who's the originalist justice, like Justice Scalia, who's the living constitutionalist justice, like Justice Brennan, who's the pragmatic justice, like Justice Breyer. We Americans now know these differences exist. Well, they do exist. Nothing prohibits a state court from saying, well, you know, we don't agree with that Justice Scalia opinion. It's an originalist opinion. We're living constitutionalists. We let the meaning of the words of these guarantees evolve over time. And vice versa. You could have a U.S. Supreme Court decision that evolves over time, the meaning evolves over time, and a state court that decide, no, we're a little more strict. We're going to be originalists. So you can have disagreement, and that disagreement is perfectly appropriate. We should respect it, and there's nothing wrong with a state court charting its own path solely because they disagree with the analysis of the U.S. Supreme Court. Federalism not only allows it, it embraces it. The third explanation is the best explanation. It turns out the liberties we care so much about are written in highly general terms. In Larry Tribe's words, majestic generalities. It sounds so good. Equal protection, due process, free exercise of religion. No one can say there's just one way to construe those generalized terms. I mean, even the originalists with a case about modern technology and the Fourth Amendment, unreasonable searches and seizures, they have no way of saying what the framers in the 18th century thought about that guarantee in the context of a GPS system or a cell phone. So it's quite clear that those generalized terms have lots of imperfect options. So in a world with 51 imperfect options, why? This is my most provocative question. Why are we Americans insisting that the U.S. Supreme Court embrace just one imperfect option? At a minimum, we should think it's worth trying out these different approaches. So that leads to the so what part of the talk. How can this actually make a difference, and what good could it do? Well, I hinted at the first benefit of this. I'm pretty confident everybody listening, and I realize a quarter of you aren't based on my experience, but everybody else would all agree with Justice Brandeis's wonderful insight. Justice Brandeis was a progressive, wonderful lawyer, and then on the U.S. Supreme Court for a while. And we think of the laboratories of experimentation. That's a quote from Justice Brandeis. And what Justice Brandeis was referring to was very much a federalism idea. And the laboratories of experimentation is plural. It's the states. It's not the U.S. Congress. And the idea with these 50 laboratories was their legislatures would try out different approaches to solving different policy problems. And if one state had a good idea, other states could adopt it, or other states could try a variation on that idea and try something else. And over time, if an insight emerged that really made the most sense, Congress could nationalize it. So I think we all agree that Brandeis had a great insight, and that's a wonderful virtue of federalism. If I've got you in agreement on that point, why can't we all agree that the same should be true with laboratories of experimentation in construing the constitutions? They're highly generalized guarantees. They're dealing with new policy problems facing the country every year. Why are we insisting on one imperfect approach right off the bat, adopted by the U.S. Supreme Court? I mean, I know why. We're Americans. We always think we'll win. But we don't always win, and you don't always get what you want. And it usually makes sense, as Brandeis pointed out, to try things out for a little while before you nationalize anything. And that insight applies to legislatures, and it applies to the courts, and it would be very healthy for the U.S. Supreme Court to have a world in which the 50 state courts were aggressively, independently interpreting and experimenting with their own highly generalized guarantees. There's something else that's good about this, although maybe this is the weakest part of my argument. It's completely neutral. I know no one's looking for anything neutral in this day and age. Everyone wants their own orthodoxy. But this is something that Justice Brennan embraced. I mean, in the last 60 years, I would say the two most significant justices in the U.S. Supreme Court are Justice Brennan, a liberal, and Justice Scalia, a conservative. Justice Brennan wrote an article in 1977 embracing everything I have said so far. Justice Scalia, in his last majority opinion for the court, a case called Kansas versus Carr, said the same thing. The states may experiment all they want in construing their own guarantees, and often do in the aftermath of U.S. Supreme Court decisions. Why else might this work? Well, it's worked before. So I'm going to talk about two cases, Barnett and Buck versus Bell, where the states actually played a much more meaningful role than most people appreciate. Well, thanks to Greg and the Jackson Center, most of you know a little bit about the Barnett case. This is a case that really started in the 1930s. We used to do the Pledge of Allegiance in all public schools in this country. And for a while, the Pledge of Allegiance ceremony had a mandatory arms salute. I think it was called the Bellamy salute, I think? The Bellamy salute in the middle of the pledge. The Jehovah's Witnesses, a Christian religious sect, did not take kindly to this requirement because they thought in worshiping a flag, you're worshiping something other than God. And that was the approach of their faith. And as a result, families in public schools throughout the country, Pennsylvania, West Virginia, but throughout the country, it's really hard to think of a state that wasn't affected by this. The kids were expelled when they refused to pledge the flag, and sometimes their parents were criminally prosecuted for supporting child truancy. It's really an unfortunate episode in American history. And sadly, all of the courts, the federal courts and the state courts, failed when litigation arose trying to protect these individuals' right to speak freely, whether to say something or not, and whether to worship something they preferred not to worship. That leads to a U.S. Supreme Court decision in a case called Gobitis. And as you probably know, that's an 8-1 decision where the U.S. Supreme Court rejects the claim quite categorically. The one dissenter barely writes a dissent. But within 3 years, so between 1940 and 1943, the U.S. Supreme Court flips on the issue, perhaps motivated by a couple things. One, watching this remarkable persecution of a religious minority in this country. Second, the Nazis didn't do much for the Gobitis decision. As you may remember, the Nazis were into raised arm salutes. I think that started to embarrass people on the U.S. Supreme Court when they started to see that analogy. So on Flag Day, June 14th, 1943, the U.S. Supreme Court flips. It goes from an 8-1 decision rejecting the claim to a 6-3 decision supporting the claim. It's written, of course, by Justice Jackson. And it really, I think it's fair to say Brown versus Board of Education is the greatest civil liberties decision in this country's history. But in a lot of ways, Barnett sets the stage for it, because Barnett, the way it's written, the way Justice Jackson writes it, it's about the fact that the Bill of Rights and the 14th Amendment protect the rights of the minority, whether it's a right to speak, worship, whatever it might be, whether it's race discrimination, and Barnett really sets the stage for that. I'll just read one part of it because you can't read this too much. Justice Jackson's great line: "If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein." And it's a great lesson. If we can't have orthodoxy when it comes to saluting the flag, maybe we ought to step back with all the other orthodoxies we seem to have in this country right now. So it's a wonderful lesson. That's the part of the story you may know a little bit about or dimly remember. Here's the part of the story I'm pretty confident you don't know. It's that during this period of time, both before Gobitis and then most importantly Barnett, the state courts were litigating these same issues. And the state courts, after Gobitis, not before Gobitis, but after Gobitis, did a wonderful job appreciating the role of their state constitutions and the U.S. Constitution in looking after the rights of the dissenter. So to me, first lesson of Barnett is not what a great justice Justice Jackson is, although I get the idea. First lesson for me is the state courts did not do a worse job, and in fact, in some ways, had done a better job construing their own constitutions. That leads to the Buck versus Bell story, which again is a story you partly know and perhaps partly do not know. So the part you know can be set up by the eugenicists. It's just so stark, their beliefs. So eugenics was a movement that started in England in the late 1800s and really captured the establishment in the early 1900s. I'm now quoting a eugenicist, and certainly not me. Nearly all the happiness and nearly all the misery of the world are due not to environment, but to heredity. That the differences among men are in the main due to differences in the germ cells from which they are born. That social classes, therefore, which you seek to abolish by law, are ordained by nature. That it is, in the large statistical run of things, not the slums which make slum people, but slum people who make the slums. That if you want artists, poets, philosophers, skilled workmen, and great statesmen, you will have to give nature a chance to breed them. Now, that was not the mission statement of the Chautauqua movement. So the part of the story that you know is a sad part of the story. The U.S. Supreme Court is clearly the villain in this story. 1927, in an 8-1 decision, another bad 8-1 decision, the U.S. Supreme Court rejects the claims of Carrie Buck, who asked to stop the state of Virginia from involuntarily sterilizing her. And that's the decision that has the infamous line, 3 generations of imbeciles are enough. Quite sadly, after 1927, 15 more states passed eugenics laws, and the movement really grew quite a bit. Again, the Nazis were not good for eugenics. That's really when this country started to think, have second thoughts about it. Here's the part of the story I'm pretty confident you don't know. So the eugenics legislation was first being passed in the early 1900s. The Buck versus Bell case is not decided till 1927. What happens in between? In between, there are 8 lower court cases, 6 of them in the state courts. Of the 6 state court cases, 5 of the 6 decided correctly, which is to say, embrace the claim of the individual challenging the eugenics legislation. The one state that gets it wrong, the Washington Supreme Court, is reversed a year later by its legislature, which gets rid of the law. So here we have a story where, clearly by the verdict of history, the U.S. Supreme Court got this wrong. The state courts got it right. You should read the Smith decision from the New Jersey Supreme Court. It's a wonderful decision which really illustrates that the state courts can play a role in counter-majoritarian rights protection, and in fact have done so in history. One of the saddest parts of this story, and I think it's really shows it's embedded in our culture and in our legal norms, is that after 1927, suddenly the activity stopped in the state courts. So just think of how jarring that is. Before 1927, individuals who did not like the eugenics legislation won 7 out of 8 cases, stopped the involuntary sterilizations in their path. After 1927, when the U.S. Supreme Court speaks, 15 more states passed eugenics laws, and no one goes back to the state courts. No one believes a second shot is worth it. It's mystifying to me, right? They had just won 7 out of 8 cases. Now that they've got 15 more states passing eugenics laws, no one's willing to go back to the state courts and use the state constitutions to enforce their rights. So the problem we're talking about is not a problem in the last couple decades. It's a problem that's almost 100 years old. And I think it's just embedded in the norms that we think so highly of the U.S. Supreme Court. Usually it deserves it. I'm a federal judge. I mean, I should like federal judges. I should respect federal judges. But the problem is I know federal judges, and we're no better than anyone else. And so there's no perfect court, there's no perfect judge. And if you're living in a world with lots of imperfection, it's a pretty good idea to spread the risk rather than focus it in one place. So let me try to make this relevant to today and talk about a couple decisions from the U.S. Supreme Court, which will illustrate the role state courts still have to play and some of the complexities over what's going on in American constitutional law today. So one case I suspect you heard about, I only talk about controversial cases, that's just what I'm about to do, warning, is a case called Masterpiece Cake. This is the wedding cake case where a gay couple asked to have a baker bake a wedding cake that celebrated their marriage. And he refused, and he was prosecuted under the Colorado Civil Rights Law and went to the Colorado Civil Rights Commission. And the long of the short of it from the U.S. Supreme Court's end is they recognized his claim, but in a very idiosyncratic way, in a very limited way. So we're still left with a very difficult issue to resolve. At least if you read the U.S. Supreme Court decisions, it looks pretty difficult. Because here's what it is. It's a little bit like the Barnett. It's really Barnett versus Brown in a way. Because you could think about Brown as being just like gay rights. It's a discrete minority that has been discriminated against historically, and as in Brown, all of those vestiges of discrimination need to be removed. All right, so that's the Brown part of the story, which makes it look quite easy for the gay couple to win. But it has a Barnett component to it. The Barnett component to it is the baker's position, which is, I'm the minority. It's not the gay couple that's the minority. I'm the minority. I have an Orthodox faith. My Orthodox faith says not to support gay marriage, and baking and the way I bake my cakes is a form of expression. To the baker, this was a case about compelled speech, just like Barnett. And if you read the briefs, you see the two sides fighting this out. To me, the role state constitutions and state courts have to play right now is not that we're going to fix this problem or get Americans to all see just one side of it. It's too complicated for that. What does seem valuable to me, however, is to let the state courts dealing with these imperfect options, in what is a hard case, try to sort it out for a couple years, see if a winning insight emerges, or see if time helps us figure this out. A little more tolerance on both sides. I mean, one of my big objections to all of this is we spent 150 years trying to eliminate the concept of other, only to create new others. I mean, the goal is no others. That's the goal here. And maybe a little bit more time will help us there. But the state courts have a very valuable role to play in that. So that's one case. Another case you might have heard something about is the partisan political gerrymandering case, Gill versus Whitford. That case is a lot like Masterpiece Cake. The U.S. Supreme Court did not announce a winner-take-all ruling. It ducked the issue by saying they didn't have jurisdiction to review it. That leaves a gap for state courts to fill, and state legislatures and the people of the states to fill. And that's happened. In my state, Ohio, there was a state initiative that, I'm not going to say fixed. The word fixed is very hard to use in this context, but definitely improved things in the state of Ohio. If some of you are from Pennsylvania, you know there was a Pennsylvania Supreme Court decision that interpreted the Pennsylvania Constitution to create some rules here. The North Carolina Supreme Court has done the same thing. There's some real virtue to allowing the states to experiment with this while the U.S. Supreme Court sits back. I mean, I realize we're not a patient group of people, but there is some value in letting the state courts, at a minimum, lower the temperature. If you nationalize a right when you're only affecting 5 or 10 states, it makes it quite a bit easier. The last case, which got a lot of attention, is a case called Janus. This was another free speech case. It's another case where Barnett was very much figured in the analysis. The question was, what do you do with members of public unions, and whether they could be compelled to provide agency fees for the union? The union's position was, hey, we're the minority here. No one likes unions anymore. And the union members that didn't want to pay, they thought they were the minority. Once again, that's what we're fighting about in this country. Who's the minority? Who's the group or who's the person that has the claim on counter-majoritarian protection from the court? Well, Janus is a case which nationalizes the issue. Okay? This is a case where there is no role for the state courts or state constitutions to play. They just took it over. The free speech, when the federal free speech clause applies, no state can reject that and nullify that. There really isn't much of a role for the states to play. So it kind of illustrates what we have. When the U.S. Supreme Court occupies the field, as they did in Janus, there really is no role for the state courts or state constitutions to play. When they either reject the claim or stand back for a little while before they decide what to do with the claim, there's very much a role for the state courts and state constitutions to play. So the way I'd finish up, I mean, it's wonderful. David Brooks, he's got to be getting ready to write a book on localism because he's got one opinion piece after another on localism. Everything I'm talking about is localism. There was another piece in the Times today about that we're misreading the role of the states in our elections, both national and state. It's regional. And that article has a wonderful insight. I really think we're talking about regional differences much more than we are talking about state differences. And everything I've said today is a localism, regionalism point. It's not saying we don't have a U.S. Constitution. It's not saying we don't have a U.S. Supreme Court to protect national rights. It is saying, let's think about going to all 51 places and not just one of them for this winner-take-all solution. Sometimes winner-take-some is the right way to go. So, I'm a Chautauquan. You can have an idealistic Chautauquan movement in the 19th century. We're going to have a state constitutionalism movement in the 21st century, and this is the first place you heard it. So thank you.